Hi everyone, welcome to another episode of TaxSnax. This is just going to be a quick rundown of a case we had recently in the upper tribunal in which Rebecca Sheldon successfully acted for HMRC, and it was Rafferty and HMRC. So just a quick background for the case. HMRC had opened an inquiry into Mr. Rafferty's 2014-2015 tax return and then later issued a discovery assessment covering tax years 2001 and 2 to 2013 to 2014, then from 2015 to 2016, and then 16 to 17. And they also issued a penalty determination for failing to comply with information requests and for deliberate underreporting of income. The FTT dismissed Mr. Rafferty's appeal, and they upheld HMRC's decision for the tax assessments and the penalties. But then the appellant made an appeal to the AUT on procedural and substantive ground. And there were sort of three main grounds raised. The ground one was on procedural irregularity, and Mr. Rafferty alleged bias in the refusal of the appeal. He also said that HMRC had incorrectly assumed he lived with his wife and children between a period of 2002 to 2016, and that had led to flawed tax calculation. And also there was introduction of evidence at the FTT hearing, which he said HMRC had allegedly introduced a document during the hearing without prior notice, and that the FTT had misinterpreted the facts, which had led to how they had looked at the assessment of the family benefits, income, and his ability to attend hearings. But essentially, the upper tribunal found that the FTT had sufficiently considered the evidence and made reasoned conclusion. And they said that they agreed with Ms. Sheldon's submission that if there were two households, the financial position of Mr. Rafferty would be worse, not better, as it is more likely than not that his expenditure was increased. We find that in relation to the issue of whether there are two or one households, the FTT, 1, took account of the relevant evidence, and 2, made a decision on a fact on issue and gave sufficient reasons for its decision. And then, therefore, they found that in regards to ground 2, the FTT made no errors of law. Ground 1. And ground 2 was in respect of the validity of the discovery assessment. This was not a ground of appeal on behalf of Mr. Rafferty, but it was one that was raised by Judge Jones. So, with the legal, Mr. Rafferty questioned the legal validity of the assessment and argued that HMRC had no basis to issue the discovery assessment since the relevant financial information had already been provided. He also said that FTT had failed to correctly apply legal principles regarding what constituted a discovery under tax law, and that HMRC did not meet its burden of proof to prove a discovery required. And the upper tribunal found that HMRC had properly established a discovery as new interpretations of existing information could justify assessments. It held that the FTT had correctly applied the law. It stated that in its judgment, we are satisfied and find that the FTT made no errors of law by misapplying or misinterpreting the statute and case law when upholding HMRC's discovery assessment. In our judgment, no new information of fact or law is required for there to be a discovery. All that is required is that it has newly appeared to an officer acting honestly and reasonably, and that there is an insufficiency in an assessment. That can, for any reason, including a change of views, change of opinion, or correction of an oversight. And then there was a final ground which addressed the penalties for deliberate conduct. And in that case, the upper tribunal also ruled that the FTT had correctly applied the law on deliberate conduct and found sufficient evidence that Mr. Rafferty knowingly underreported the income. He had argued that the HMRC had failed to show that he had intentionally misinterpreted income, and also claimed that the FTT did not provide clear reasoning on why the penalty was imposed. They stated in their judgment, we are satisfied that the FTT, 1, identified and applied the correct test of what constitutes deliberate conduct, and 2, identified and applied the correct burden of proof, that being on HMRC, to establish whether there had been such deliberate conduct. And so, in conclusion, the appeal was dismissed, and it was concluded that while the FTT's reasoning could have been clearer, it had made no legal errors in upholding HMRC's assessments and penalties. So, whilst a brief overview of the judgment, it's an important one to see how the UT had looked at the FTT's decisions and the appeal and closure notices, and looking at discovery assessment and the various penalties for deliberate behaviour. And it was a helpful one to see all those set out, and ultimately the appeal was dismissed as successfully represented by Rebecca Sheldon. So hopefully that's a quick overview, but a helpful one and a good judgment to read on this area. Thanks everyone. Hope you that was helpful.